So our next speaker is someone who the Bar Association is very, very familiar with. Judge Elvis Patea has been here since 1992. He became a member of the Hawaii Bar in 1985 and acted as supervising attorney for the Maui Office of the Public Defender. In 1992, he came back to American Samoa, where he served in the Office of the Attorney General as an Assistant Attorney General and the Deputy from 1994 to 1999. He then went on to work at ASCC for 5 years before turning his sights to the High Court of American Samoa. Since 1999, he was a District Court Judge pro temp and became a regular District Court Judge in March of 2009. Since September of 2010, he has been an acting Associate Justice, sitting by designation, and he is here to speak with us today about the administration of justice in the High Court. As we mentioned, a strong, independent judiciary is vital to promoting the rule of law, to keeping a strong democracy. The High Court is undertaking a new case management system, which he is here to describe today. The Bar is very excited about this initiative, and we're very much looking forward to working with the High Court on this. Judge Patea?
Sean just mentioned that I'm here to speak about the administration of justice in the High Court of American Samoa. That's a rather wide topic. I thought I was here specifically for the case management system, but I suppose that's one aspect of the administration of justice, so I'll concentrate on that aspect only. I suppose in getting to the new case management system that we're putting into the High Court and the District Court at this point in time, it helps if I go over what we actually have now, which is almost nothing. As you all know, with your dealings with the High Court, specifically the clerk's office, everything is manual. For instance, the docketing, our case numbers are assigned manually. They're logged on paper, they're stored in binders, and then from there the cases are pretty much left to the attorneys to drive them to their disposition. There's no active management on the part of the judges, the court, to push those cases along and see them to the end. And as a result, all of you know that a lot of those cases have just languished, some of them far too long. The search. Attorneys come in for a search request. The way things operate now, if you don't have a case number, pretty much you're out of luck. And if you don't have that case number, that means the clerk has to manually go through those binders, dockets, to look for the case number. And for attorneys and members of the public who want that case, usually yesterday, it's inconvenient, because the clerk has to sit there and go through binder after binder to look for that particular case number under the names that have been logged in manually into this binder. So that doesn't work. We need to, thus the need to move into the technology age that we should be in right now. Calendaring. Well, all of you are familiar with the master calendar, that huge cumbersome board that they lug around between the two courtrooms. And a lot of times, there's just confusion. You end up, there's conflicts between cases that are scheduled, trials or hearings. And a lot of times it just doesn't work for attorneys either, because you have to be in two courtrooms at the same time. The realization is there's got to be a better system than what we have now. So the bottom line with what we have now as far as cases that come through the High Court, there simply is no management. Thus, the need for this management and a better management system has long been recognized. But of course, like everything else, you need money. And we all know that there's not a lot of that going around, especially after the millennium. But sometime in 2006, staff got together and decided to brainstorm and start identifying our needs on what we thought an optimal system should be like. Then came the process of applying for grants, and then finally we were given a grant by the Department of Interior, and that came through their Technical Assistance Grants Program, and that grant was given to us in April of 2009. And that was just half the battle, because after that we have to put out RFPs to comply with all of the procurement laws of the territory. We worked with the procurement office, and that whole process also took a while. We started the first procurement went out sometime in 2009, then the tsunami hit, and then the procurement process kind of got put in the back seat. It just didn't go anywhere. A second RFP had to be put out again, and that was done in March of 2010. We finally were able to issue a contract or award a contract in January of 2011. And it was to a company called New Dawn. New Dawn is a small company out of Utah. They currently are installing the same software, and it's called Justware, in Guam, simultaneously with us. They have already installed the same Justware software in the CNMI. And during one of our conferences, we were able, both the Chief Justice and I, and also our Clerk of Courts, was able to see Justware in action in the CNMI, and we were quite pleased with the way it works. And thus, when Justware applied for responded to the RFP, that was our choice, and the contract was awarded to them. The contract with Justware, under the terms of the contract, was supposed to go live by July of this year. We've hit a few snags. It'll probably be delayed 2 or 3 months beyond July, but we're bound and determined to make sure that this goes live. We have a new case management system in place before the end of this year. Some of the features of this new case management system, it should tie the district court and the high court together. Right now, district court's traffic records are not accessible by the high court. Probation they create their own records with their own language under some software called File Amigo, and only they have access to it. Nobody else in high court or district court know what's in the probation records. At least with, and also financials. The financial system is separate, and this is information as far as money held in trust, collected for revenue, etc. Pretty much people in both courts don't have equal access to it because it's, again, in its own separate software. This new case management system should tie everything together, and both certain, depending on your security level, in high court and district court, you'll all be looking at the same information. The ability also of Justware to build customized reports, not only automatic reports but ad hoc reports, is one of the more interesting or the nice, I guess, features of Justware. For instance, one of the reports that the software should be able to produce either automatically or on demand by a particular judge is to list all of his cases that are pending before him at any given point in time. I can tell you that today, if Justice Richmond was to call up the clerk's office and ask how many of my cases are pending and what's their status, nobody would know. We simply don't know. And that's a disadvantage of having a manual system like we have right now. Under Justware, we shouldn't have that problem anymore. Justice Richmond can come in the morning and ask Esther, call up all of my cases that are under advisement, or call out of my cases where nothing has happened from the attorneys for the last year. So those type of reports will now be able to be generated by the Justware software and better equip the court, judges, clerks, to make sure that the cases are managed, that they light the fire under the bar and move those cases along to a disposition that's acceptable not only to the judiciary and the bar, but also to the public. One other aspect, feature of Justware is we should be able to automate document templates. A lot of times we depend, especially in the criminal area, right now we depend too much on the bar to produce documents, specifically judgment and sentences. And given the the comings and goings of assistant AGs in the AG's office, where some of them leave without producing those JNS, cases will just remain open with no judgments. One of the features of the Justware software should be able to automate those templates and produce a JNS by the courts immediately instead of depending on the attorneys to produce documents. The calendaring of hearings and events, right now, at least with the different styles between the different clerks for each of the judges, sometimes all of their personal events as well as their court events, hearings are noted somewhere. But that not may be always the case. At least with Justware, everything will be in there. So, for instance, if the court wants to set a hearing or the parties request a hearing for 10:15, the clerk can remind the judge, you have a dental appointment that morning, so they won't set anything beyond 10 o'clock. Any hearing that will go past 10 o'clock from 9 o'clock, they shouldn't set it that morning. So it will incorporate not only the judge's personal appearances, but also the official calendar to better serve everybody involved. And of course, everybody's favorite, especially the clerks, they should be able to search now not only by case names, but by case number. So if somebody comes in and they don't know the case number, at least they give the name, a first name, a last name, a middle name, an AKA. Whatever they give, Justware should be able to pull up that name, and if it's a list, it can narrow down. They can narrow that down to until they get a specific case that they think the parties need. Now, having said that, we all need to remember that this case management system, Justware, is for the internal management of the cases for the judiciary. Now, what happens outside the bar, in the bar, and how you manage your cases, that'll be still your own thing. But at least now the courts will be online as far as trying to manage cases and moving them along without the entire system being attorney-driven. To give you an idea of how this lack of a proper case management system has resulted in a backlog of cases, too many for far too long. We started reviewing old cases last year, and I was given the assignment of reviewing the land cases and the civil cases. My review of land cases from 1986 through 2005, out of that amount, 196 were set for calendar call. And out of that 196, 192 were closed. So there were 192 cases within that period where nothing was happening, and they had to be closed. In the civil area, the review was made of cases as far back as 1989 and brought all the way up to 2007. With the exception of 2000, because those files were affected by the tsunami and they're being restored in Texas. And of all the cases that were set for calendar call, it came out to 375. And out of 375, 361 of them ended up being closed. Again, only 14 cases moved on for further action before the judges. So 361 cases sat around for all those years with nothing being done on it. So the goal of this case management system, of course, is to keep track and move cases along to disposition in a reasonable amount of time. Now, how can the bar help? The Chief Justice issued a memo towards the end of last year, and one of the items in there was he had called upon the bar to look at benchmarks for the progress of these cases. And Justware will write those benchmarks as business rules into the case management system. Now, I have to say that the criminal cases, it's not that much of a problem. There are very, very few cases that fall through the crack. Pretty much the criminal cases, everybody has a handle on it, both in courts and out there in the bar. But it's all the other cases, the civil cases, the land cases, the Matai cases, the probate. That's where the problem is. These are the type of cases that need those benchmarks, that need those timelines. Here's an example of how it should work, or at least an idea to put out there to the bar when you start discussing those benchmarks and bringing it to the court. Automatically setting for status hearing after a complaint is filed and there's no default judgment. Possibly setting that status hearing in 45 or 60 days. Because right now, after that case is given a case number, logged, put away in a binder, and filed away in the vault, nobody goes back to check on it. Something will only happen to that case when the attorney files something to bring it back in front of the judge. By setting these benchmarks with the understanding of the bar, in 45 days or 60 days for a status hearing after a complaint is filed, it forces the parties to come back into court and for the court to say, what's happening here? Now, when I say complaint and before a default judgment has been filed, we need to find out why has it not been served. Because if it's been served, obviously somebody should be moving for a default judgment. Thus, the 45 to 60 days. Another example is automatically setting for a status hearing after the answer is filed and allowing time for discovery to take place. Now, depending on the complexity of the cases, the benchmark that everybody can agree on could be 4 months, 6 months, however long the bar determines based on the different issues involved in those cases. Those can be worked out. Those can be presented to the judiciary. Those can then be made either by way of rule or a judicial memo, part of these deadlines to be set into this case management system. This way everybody knows what's expected of them and everybody knows when their case will come up again before the court automatically without the court waiting for the parties to bring it back in front of them. All right, so that's where we are with our case management system. And hopefully, like I said, we will have it in place before the end of the year. As far as any future projects for the court, and again, everything depends on funding, and therefore means we have to look at writing grants and basically begging. One of the things that we're looking at is digitizing the entire 100 years worth of files that are back there in that vault. They're nowhere else. If we can have all of that digitized, just like the U.S. have their census digitized, then they can be placed on a website and they can be accessible by everybody. And even if we don't get that far, at least they will be in some form at the courthouse that anybody can come in and look at them on a computer with the help of the clerk, with the assistance of a clerk, but at least they'll all be digitized and easily accessible, because at least by then they should be indexed and people can look for them easily. That's a future project. Hopefully it'll happen in my lifetime, but we'll see. And that's it for the case management system. I think by working together, I'm confident that between the bar and the judiciary, we will continue to promote justice for a lot more years to come. Thank you.
Does anybody have questions for Judge Patea about the management system and about some of the court's projects?
Tala?
Yeah, Judge, I'm sorry I may have missed this, but would Justware have anything to do with electronic filing of meetings, documents?
That is one component that's available or that can be tagged on to Justware. However, that's not part of what we're getting right now. It is something that certainly we've looked at and can look at it again in the future. But I think we're taking things slowly. I'm not saying that it's out of the question, because a lot of jurisdictions have allowed electronic filing, and it's it's just a lot more convenient for the bar. We'll get there, I think, at some point, but not right now. It's not part of what we're installing.
I guess, Judge, in the past we used to have motions day, where an attorney would be able to set a motion on his own. He would be able to pick a day, and on that day, he would hear that motion, which I think would make it a lot easier, rather than having to wait for the court to always set the date. Because this is something that the attorneys can probably work out and get a date, set it for a motion day, 10 days or 2 weeks after the motion was filed.
In both attorneys?
Yes. Well, it doesn't matter. It could be a day that we have to. A motions day is what a motions calendar. We used to have one.
When was the last time they did that?
It's been over 20-something years.
Yeah, and I think it just depends on the preference of the justices to which the cases are assigned. Now, once it's assigned to, for instance, Justice Richmond, he'll have his own days that he'll want to hear matters. Now, if he designated a motions day, I'm sure that that can be done on that particular day, and the bar will know what day all his motions will be set. But it's up to the individual judge's preference. But I'm sure as part of the benchmark setting that the bar, I'm sure, will delve into and present to the judiciary as in setting the case management system benchmarks, that can be suggested. Charlie?
Yes, Judge. A lot of the delays that happen at post-trial deal with connecting, especially in land cases, deal with connecting the registrations directed by the court or decisions by the court and sending that over to the registrar's office to be able to get the resolution clearly indicated. Is there anything in that procedure where there is that connection with the registration that got denied? Is there a way that the registrar's office will have full knowledge of that, or is that just basically is that just basically then left to the registrar to come and find out what happened in the court case, or parties to go send it back to the registrar?
Yeah, pretty much right now, I don't think the registrar will take time out to come and find out what happened to cases that are So it's incumbent upon the attorneys for the parties, especially the prevailing party, to get that judgment over to the registrar to make sure that the correct judgment is carried out over at the registrar's office. As far as the case management system, no, we didn't anticipate that, Charlie, but that's certainly something we can look into to include them on the distribution of these orders, especially in LT cases.
And also, with these matters that are coming up through tie registrations and land registrations, as you know, we go first to the territorial, they file first with the registrar's office, then it goes through the Samoan Affairs or through, and then up to the court. And at that point in time, in some cases, attorneys are involved. In other cases, the court then sends out these notices to the parties to take action. A lot of the delays that happen in the tie cases because we're not too sure exactly at what stage a particular registration is, whether it's between the Samoan Affairs and the court. And then the question then becomes, who takes the action? And then in a lot of cases, things are just kind of in limbo for a long period of time between that Samoan Affairs and the High Court. Is there any effort to really try to streamline that so that Samoan Affairs gets that letter over to the court in time and that the parties can get it?
Again, that can all be part of the benchmarks that we're talking about that's built into the case management system. If the bar convinces the judiciary that the benchmark for perhaps that lag time to get into Samoan Affairs is 1 week or 1 month. And when it gets to Samoan Affairs, we'll give them 3 months or 2 months to go through the process, and it'll show back up again on the court's calendar because the case management system will flag it saying you have a status hearing on the 60th day. Everybody will come back into court on that 60th day and tell the court we're still meeting, or we haven't gone anywhere, or we're done. At least with the case management system flags this benchmark, on this benchmark day, say that come into court for this status hearing, tell us where we are. That's the way to keep everything on track.
Yeah, the one I'm talking about is that first round between Samoan Registrar, Samoan Affairs, and then to the court business. And that, at that point, there is really no case before the court to start flagging.
I understand, but a lot of times the attorneys aren't even involved in that process. I don't know that there is there's a proper solution at this point in time for that, but it's certainly something that can be looked into, because a lot of times with those parties going between the registrar and Samoan Affairs, they have not gone to attorneys yet.
I actually have one. So you were talking a bit about the just where giving the court and the judges kind of a calendar, a master court calendar of what is happening, including their own schedule. Will the bar have any access to that calendar so that we can then go on and look at it and say, can I at least look up the cases that are under my name for this week or for this month? So, I mean, I enjoy getting Terry's emails with the court calendars, but maybe if I were able to go in and see a master calendar and maybe search by week or attorney, that might help a lot.
The calendar that I'm talking about in Justware is for the use of the court and its the clerks and the judges in setting their cases or setting their schedule. There's no reason why that information can't be extracted and made available in a abbreviated form for the bar, so that way the attorneys can go in and look at certain information, cases only and their names, as opposed to everything else the judge had put on there, which may include his notes. I don't see why that can't happen. It's something that can be worked out between our IT person, Artie, and our clerk of courts, Terry.
Any other questions? Or just pay them all we got up here? All right, well, thank you, Judge.
All right.
Yeah, that was,
Thank you very much.